Kim Duggan is the founder of Duggan Law PC, and she's been practicing estate, wealth, and legacy planning law since 2000. So many people are dealing with this right now, trying to figure out their documents, their living trust, etc. And she is really here to help us answer some questions, especially so our family members can get along even after we're gone. And her practice does go beyond just, the legal documents. She's education, counsel, and really that personal touch to help clients, you know, make their decisions and move through the process. She's been doing this for a couple of decades, and she really is a partner that you want to trust. And she works, one-on-one, or she speaks to groups like us, and she's very generous with her time and information. And so please use this time to really, ask her the questions that might be kind of weighing on you. And so with that, Kimberly, thank you for joining us, and I'm turning it over to you.
Thank you, Christy. Yeah, I tried to speak in layperson and not legalese, so hopefully everyone will follow along. I'm going to share my screen now. Does everybody see that?
No, not quite yet.
No.
Oh, okay. Let me try again. Oh, I didn't press the share button. There we go. We've got it. So welcome, everyone. Thank you so much for coming out early on a Friday morning. And I know everyone, it looks like, already has their coffee or has already drank their coffee and has moved on to water, as I have. I really want to thank Christy and her entire team and the Platinum Resource Group for inviting me here to speak with you on this important topic. And as Christy said, I'm Kimberly Duggan. I'm a life and legacy attorney, and I've been practicing since 2000. One thing she didn't mention was that in addition to working at law firms and helping clients, I've also worked at both the San Francisco and San Mateo County probate courts. So I have that experience of seeing the conflict in action and what can go wrong. And that is really helpful in planning, is seeing the back end so that then it's easier to plan around it. I want to open by acknowledging that estate planning often feels overwhelming and uncomfortable for people. Nobody likes to think of their own mortality. So let's think of this today more as a conversation with a small group about a difficult but very important topic, because what you're trying to protect here are the people you love the most. And most people, when they think about estate planning, they probably think about a list of all of their assets and where they're going to go at their death. But the truth is, it's about so much more than that. It's about your values. It's about the people you love and what kind of mark you want to make on this world and your community. So today I want to show you how planning protects not just your wealth, but the people you love and the family harmony, because it comes into play when you're not able to stop those squabbles. And so how can you plan around that? So first, let's get through the disclosures. This is for educational purposes only. It's not intended to constitute legal advice. And because there may be some people in the audience today who are not from California, I just want to let you know that I am only licensed to practice law in California. And so anything I refer to is going to be California law. But the concepts I'm talking about are really universal. So I think everybody can gain something from this. So what are my objectives today? My goal isn't to make you estate planning law experts. My goal is to get you thinking about what matters most to you, your family. And by the end of this presentation, you should have a basic understanding, at least, of a foundational estate plan and why it's important, where families often fight and how that conflict arises, how planning can help you reduce that conflict. There are ways to plan around that conflict or things you can do to help avoid it. Then we'll go into a few advanced estate planning strategies for professionals, including wealth transfer planning and tax planning. So these are typically about money, it's true. But once you get that foundational plan in place, sometimes then people want to take that extra step. How can I also save money? How can I better shift money to a next generation? How can I also protect that next generation from the world or from themselves? And there's a real emotional impact involved in all of this, both on the side of the person who's creating the plan and on the side of the beneficiaries. How is what you've created going to actually play out when you're not there? And are you going to be able to keep your family together the way you're probably hoping? I don't know many parents who say, yes, when I die, I hope my children never speak to each other again and they just fight. Usually the parents like, oh, my family is wonderful and they're never going to disagree. The reality is somewhere in the middle, probably. But based on how you plan, you can increase the likelihood that your children will still communicate with each other after you're gone. So think about your legacy. It's about more than just money. Typically, people think of their things, their assets, their stuff. That's their legacy, especially when they're thinking about estate planning. And it's true, if you look up the definition of legacy in the dictionary, the first thing it says is an amount of money or property left in a will or trust. But that's not the only definition of legacy. The next definition of legacy is the long-lasting impact of particular events, actions, etc., of a person's life. So it's not just your wealth, it's your family, it's your values, it's the stories and memories that you cherish, and it's the vision of what you want carried forward in the future. The legacy you want to leave behind. What do people think of when they think of you? What kind of impact have you made on the world and your community? What is your footprint going to look like? And recently I read an article in a neighborhood newspaper in San Francisco about the richest man in San Francisco. Now, this man didn't have much money. He didn't own any real estate. He had a small inheritance from his father. He rented a small apartment that was, messy, almost a hoarder. But he was so loved by his community that he was considered the richest man in San Francisco. And he unfortunately died about a month ago. But what had he done for his community? Well, during COVID, he started weekly happy hours. And slowly the community was able to come together. But when COVID was over, well, not over, but when the lockdown stopped, he continued the happy hours every week. And they grew, and the community loved the happy hours and they loved him. So that's the legacy that he left behind. Even though he didn't have a lot of money, he left a strong legacy. So when you're thinking about your estate plan, it's more than just that stack of documents that you're going to receive. It's a reflection of your values, your goals, and your personal legacy, guided by trusted counsel. Because unfortunately, the DIY is fill in the blank. So that's solely about financials. And I can tell you so many stories of where it went wrong because frankly, do-it-yourselfers aren't attorneys. And so they don't know what can go wrong. And for example, somebody completed a do-it-yourself plan and they accidentally disinherited their spouse and their children and gave everything to their sister. Luckily, this person had that reviewed by an attorney before anything happened to him and he was able to fix the problem. But in looking over what he, printed out on his printer, he didn't even know what he'd done. So you want to be careful. And just think that your children, your grandchildren, the people that you care about, they're going to remember that they were loved, cared for, and respected. And while they're going to appreciate any financial wealth that you happen to give to them, the important thing really is that sense of security. Oh, I'm sorry. I accidentally moved on to the next slide. So, or me, there we go. So what does planning matter in protecting your legacy? A plan really can be the greatest gift a person gives to their family. Because think about it, something happens to you, whether you die or you become incapacitated. You know, maybe you get in a car accident, you're in the hospital and you're unconscious. What is your family feeling at that point in time? They're likely extremely stressed, emotional. The last thing they need is to also be fighting amongst themselves. And also, the last thing they need is to have to go to court, because court is time-consuming, expensive, and public. That's correct. Anyone can go in and see the public record. So you want to, by planning, you can keep your privacy for one, and you can hopefully let people know what you want, who you want to take charge, and that can avoid family conflict and help families grieve together as opposed to fighting over what you may or may not want. And sometimes, often in fact, it's not that family members are fighting because they dislike each other, but because they don't know what you want. And both have, oh, maybe she wants this, maybe she wants that. They both think they're right. And if only you'd let someone know in advance, they wouldn't have to fight over this because you would have given them those instructions. So at these times of great stress and grief, they just don't need that extra burden of trying to guess what you wanted. So a foundational estate plan includes many things. And so a lot of these you've probably already heard of or understand. I'm going to talk about how it works in California. In some states, a trust is not as important because probate isn't such a terrible process. But in the state of California, typical probate takes at least 18 months. I've seen probates that have been and worked on probates that are over 30 years old. So it's not fun. You don't want to be stuck in that. Things are tied up in court such that they're not available to your family members. It's public, and it's just not something, and it's really expensive. And it's based on the gross value of the estate, not the net value. For example, let's say you own a house in the Bay Area. I think the median value of a house in the Bay Area is over $2 million. Well, you might have a mortgage on that house, maybe a 1.5 mortgage on that house, 1.5 million, such that you only have $500,000 in net worth in that house. But the probate fees will be based on the gross value, $2 million. And the probate fees on $2 million is $66,000. And that's not even taking into account any other assets you may have. So it's really expensive in California to go through probate. So typically the basic document of all foundational estate plans in this state is a trust. And that's a revocable trust. So while you're alive, you can change it, amend it, revoke it, whatever you like. It's no different from a will in that manner. But if something happens to you, whether you become incapacitated or you die, it's a really smooth transition. The successor trustee can just step in and take over. And if you are, got in a car accident, when you regain capacity, then you can just take over again, which is not the way it would happen if your family had to go to court to take over your financial and medical decisions, because that's what's called a conservatorship. And you may have heard of Britney Spears and the Britney Spears conservatorship and how difficult it was for her to get out of that. Well, that happens to regular people too. And so a conservatorship, just like a probate, it's time consuming, it's expensive, it's public. And what's worse is it's a lot harder to terminate than it is to start if you do regain capacity. So if you have an estate plan, you can make sure that you're not conserved. And that's really a great thing. So even if you have a trust, which essentially will say where things will go and how you want them held, you make all your own decisions. You choose, one, who's going to have the legal authority to take over. Two, you give them instructions and directions, what you want them to do. So you make your choices as opposed to the court and the state of California and the California Probate Code making those decisions for you. But you'll still have a will because that's a belt and suspenders instrument in case something wasn't properly titled in the name of your trust. The will is what we call a pour over will, and it simply says, if there's anything that isn't held in my trust, pour it over into my trust so that it passes under the terms of my trust. The next document that's very important is a healthcare directive. And this is where you name someone to make medical decisions for you if you can no longer do so. And I'm not sure of the age of everyone here today, but some people may remember the case of Terry Shrivo in Florida back in 1990. She was only 26 years old when she had a cardiac arrest from a potassium imbalance that resulted in brain damage, leaving her in a persistent vegetative state. She never regained consciousness. And fortunately for Terry, she had a lot of people who loved her, and that was great. But the problem was they didn't know what she wanted. And so her parents wanted to keep her on life support. And her husband said that she told him she never wanted to be kept alive that way. Who was right? Well, nobody knew. And unfortunately, this battle was fought publicly on TV between her parents and her husband. It was in the newspapers. It was in the courts. It went up to the appellate court. The Florida legislature passed a law regarding her medical situation. It went on for 15 years, this battle between her parents and her husband, before her feeding tube was finally taken out and she was able to die peacefully. So what could have been a situation where she had said, this is what I want, or at the very least appointed the person she wanted to make the decision for her, turned into a 15-year legal battle. It's possible her parents and her husband could have remained family after her death and supported each other. Instead, they became combatants, warring for 15 years. And this is what planning can help avoid. To protect your loved ones from these kind of agonizing choices and from this kind of conflict. Another important foundational document is a guardianship nomination. And again, this is another situation where it's common. There are so many people that love the children who want to serve as guardians. There could be two sets of grandchildren and multiple aunts and uncles who all want to help. The question is, what do you want? Because most parents do have an idea about the right choice to serve as guardian for their children. But if you don't say anything, if you don't create a plan in advance, then the court is just going to be able to guess. That's all they can do. That's why it's so important. So a couple of key concepts. We talk about probate. What's non-probate assets? There are some non-probate assets. These are assets that pass like with beneficiary designation. So for example, retirement benefits and life insurance, those kind of assets will pass outside of probate, assuming that the beneficiary designation form has been properly filled out. I had a situation, a trust administration, where The husband had a life insurance policy from his work. It was $500,000 policy. And I'm just guessing here, but I know when you first start a job and they give you a giant set of paperwork to go through and fill it all out, he's probably going through this, and there's the line that says, who do you want to name as beneficiary for this free life insurance policy we're giving you? And he skipped it. Maybe he thought he was going to come back to it. He never did. What's the default? My estate, my probate estate. So even though he and his wife had created a trust, this life insurance policy had to be probated. So when you do your plan, your attorney should encourage you to check all of your assets to make sure that the plan covers everything. So what are some common sources of conflict among family when something happens? And while sometimes the conflict is about greed and money, a lot of times it's about hurt feelings. And these hurt feelings oftentimes are very old. It's about what happened at Christmas when you were 5 years old. Among siblings, you know, memory lasts a long time. So, you know, how can you plan around this? A lot of it is speaking to people. And if you're uncomfortable with that, writing to people. And I'll talk about that in a minute. But I mean, and that's just it. The lack of communication, you know, people just start to imagine the worst. I don't know why, but that's typically what happens. When people don't know, they just assume it's the worst as opposed to the best. Big conflicts often happen in blended families. Think about the Brady Bunch. What if Mike had died and he left everything to Carol? Now, they seem like a great family, and you might think Carol would have shared everything with Peter, Bob, and Greg equally. But what if Carol got remarried after Mike died? And actually looking at this room, maybe everyone doesn't know who the Brady Bunch is, but it's, you know, they each had their own children and they married and they created a blended family. So 3 children from the first marriage of one and 3 children from the first marriage of the other. So if Carol then got remarried, would she still leave Peter, Bob, and Greg everything? Maybe, maybe not. But it's these kind of family dynamics that often cause conflict. And a lot of times, this happens all the time, when the client comes in, they tell me, no, there's not going to be any arguments after my death. They all get along great. But it doesn't always work out that way. And the client's goal wasn't for his family to be warring after his death. His goal was to make a smooth transition so that his family could maintain their relationships after his death. And so that's one of the things often people don't think about when they're planning. They think about, where is my stuff going to go? Not how am I going to maintain the relationship of my family? But it certainly can be done. So it's something to focus on to make sure there aren't disagreements. Another source of conflict is mismanagement by the successor fiduciary. So if you name a successor trustee, and that person may do things wrong. And while sometimes it's on purpose, and maybe sometimes they do take money that they're not entitled to, a lot of times it's by mistake. They don't have guidance. I've heard this over and over again. Well, that's the way mom and dad did it. And that's likely true. But when mom and dad were dealing with their own money, it was their money. They could do whatever they wanted with it. But when someone takes over as a successor, they have fiduciary duties. And there's a long list of them in the probate code of what you can and can't do. And people, you know, they decide to keep doing things the way mom and dad did them, and they get in trouble. And the next thing you know, there's conflict. The other thing is outdated plans. So you created a plan 20 years ago, you've never had it reviewed. We recommend at least every 5 years. Think about it, life happens. There are births, deaths, marriages, divorces, increase in assets, decrease in assets. The tax code changes all the time. If you created a plan When I started practicing in 2000, the estate tax exemption amount was $675,000. Today, it's $13.99 million, and next year it will be $15 million. That's a very different situation for planning purposes. But also, as your children age, even, they change. You imagine one thing when they're babies, and by the time they become teenagers or young adults, they're on a different path. What makes sense? From my own experience, when I first created when I amended my trust, I left my daughter's assets in trust until she was 50, because at the time, I didn't think she was very good with finances. She wasn't. She was in college. But now she's got a job. She's graduated and changed. It's amazing how she matured in just a few years. And now I don't think it needs to stay in trust for 50 years. And these are the kind of things that could cause conflict, because previously I gave my son certain control and I didn't give it to my daughter. And that, yes, it could have caused conflict, but at the time it made sense to me. Now it no longer makes sense to me. So now's time to make that change to avoid potential conflict. So how can planning help to reduce the conflict? Explicit instructions reduce misunderstandings. So ambiguity causes confusion. For example, I'm working on a trust right now. In one paragraph, the trust says, give the home to my daughter outright and free of trust. In another paragraph, the trust says, one son can live in the house until he dies rent-free. Which is it? It's an ambiguity in the document that's, you can see, could clearly cause conflict amongst this daughter and this son. The daughter wants the house. It says, I get the house. The son says, I get to stay in it for free till I die. What's the answer? The answer is likely going to have to be court. Hopefully, we're going to work on it not being a high litigation situation. We're going to have a family mediation to try and come to an agreement. But if the instructions had been a little better, we wouldn't be in this situation. So it's about careful planning to make sure there's no ambiguities. Transparency, a huge thing, as I said before, is when people imagine why something happened. You could have an excellent reason for maybe giving one child a larger portion of your estate than the other. But if you don't express it to your children, they don't know. They're just guessing. So it's best if you can have a family meeting and talk it through. But I have a lot of clients who, for obvious reasons, aren't comfortable with that. They don't want to sit down and tell one of their children, you're getting less, because they're afraid that child then isn't going to want to talk to them as much. So what I suggest is handwriting a letter. And it's writing it in your own handwriting that's so important, because if you type it on your computer, even if you sign it, then the one child is going to think, oh, my sibling typed that and just gave it to you to sign. When it's written out in your own handwriting, it's harder to say that. You look at it and then they can understand. Now, they may not be happy with what you've chosen, but it's the understanding that helps to avoid the conflict. Get professional guidance. Don't try and do it on your own. There are lots of options. Maybe you come in and you say, I have this business I've worked my whole life to build, and one of my children is involved in the business, but the other isn't. So I want to give this child the business. So great, but is that going to cause conflict? Is the child that's not getting the business going to be upset? Maybe there are other options you haven't thought about. For example, maybe life insurance. So that your other child can get something. There could be a way to set, buy-sell agreement with the business, or a split dollar life insurance with the business. There are different kinds of options in the planning to help avoid the potential conflict in the future. So what are some, now that we've talked about the foundational estate plan and you've gotten a great foundation built and you've planned around potential conflicts to try and keep your family together and grieving together and continuing together beyond your death so that your family can still enjoy each other for holidays and whatnot. So now you want to start thinking about, are there additional planning techniques that I might want to do to save money? And like I said, this is more about the finances than it is about the family. But most people want to avoid taxes. Although it's interesting because people will come in and say, I want to plan around taxes. I want to reduce my taxes. But the question is not, great, I can do that. There's so many ways that I can save you on taxes. But what I need to know is what your goals are. Because if your goals are to have more money for yourself so that you can travel when you're in retirement, that's going to look very different. That plan is going to look very different than if your goals are to shift as much money as you possibly can to your kids. So it's important to share your goals so that you can plan for what you want to do. And professionals also often have like complex assets, stock options and retirement plans and businesses. And so these become more difficult planning situations. But it's not to say that you can't do something. There's lots of options. Come in, express your goals, and you can plan for it. So what are some of these advanced strategies? There are all sorts of irrevocable trusts. There are gifting trusts, charitable giving trust, dynasty trust. Most of these are ways of shifting assets to the next generation. So the increase in value in those assets from the day they're shifted until your death is not in your estate. It's passed down to the next generation or even the grandchildren. And so it's not subject to tax. But now, after the recent new One Big Beautiful Bill Act, there are going to be more trusts created for purposes of income tax planning. Because if the older generation is in a higher tax bracket, say a 37% tax bracket, if you can shift some of the income to a lower tax bracket generation, then the family can save significant income taxes. So if the parents shifted income to a 22%, say, tax bracket child, there's a lot of income tax savings there for the family. Plus, there's potentially double the SALT tax deduction went up. You may know that that's a state and local tax deduction. Previously, it was $10,000. Now it's $40,000. Well, it can be shifted down to the lower generation so that each generation is now getting this $40,000 deduction. There's other tax deductions too, QSBI deductions that can be taken advantage of with this kind of planning. So with the new law in place, there's going to be a lot of income tax planning in addition to estate tax planning. But that's not the only kind of taxes, unfortunately. There's also capital gains taxes. So those need to be taken into account as well. And there are reasons then sometimes to hold the asset at the higher generation because it gets a 100% step up in basis for capital gains tax purposes at death. So, and then there's property taxes. And in California, that's a huge thing to consider right now because of Prop 19. And so now when things are shifted down to the lower generation, they are going to get a new tax basis. So it's about, once again, it's about your goals. What are you trying to accomplish? And structure it the way to best do that. Then there's business and retirement assets. So people these days have huge 401k plans. They might have IRAs too, stock options. There's a lot going on. And how does this play into your plan? A lot of people do not realize that if you're charitably inclined, giving that charitable gift from your retirement assets is much better tax-wise than giving it in your trust or will. So if you leave, say, $100,000 to your alma mater in your trust, that's great. You make the donation. And then you've leave your IRA or your 401k to your child. Your child is subject to tax on that IRA or 401k. But had you left the $100,000 donation from your 401k instead, it would pass tax-free, and your child would get the $100,000 tax-free too from your trust. So they're just things to consider that maybe you haven't thought of before. And again, when you're working with a professional, they can advise you on these things. And then legacy planning too for your family. So what is it you want to do? I mean, you don't have to leave anything to your children or your spouse or anyone in the state of California or in all of US. In France, you do. In France, you cannot cut out your children. But here in America, you can. So that's what you need to decide. Where do I want things to go? Do I want to fully control them? You can control things from the grave if you want to, or you can just say, no, I trust them to do what they want with it. Again, it's about your goals. So it's important to work with someone who is experienced in this area, because it's so easy to make a mistake or a misstep, and then that might cause conflict and taxes and other problems. So what you want personal guidance. You want someone who's more than just a drafter, someone who can advise you, help you issue spot, educate you, guide you, and empower you. So when you come in, and clients do this all the time, oh, my estate is simple. I have, I want everything to go equally. Well, the good advisor is going to start asking you questions. And what happens? You find out, oh, in fact, this is a second marriage, and there are kids from the first marriage, and little Johnny has a drug problem, and. So these things come up, and then you can plan around them. But if you don't know about them, you can't plan around them. So if someone's just, filling in a form, then you're not identifying these issues so that you can solve them before it's too late. So you want to work with the right team. And that isn't just an attorney. It oftentimes includes a CPA, a financial advisor, and other team members as well. So here's a testimonial from someone whose loved one had a solid estate plan. I am thankful that my aunt made these important personal decisions while of sound mind, and that my family did not need to go through an agonizing, expensive, emotionally painful judicial process to ensure her wishes were honored. So think about that. Estate planning is one of the greatest gifts you can give your family. They're in a sense of devastation at this point in time, and you're trying to make things easy for them. You're basically telling them, I loved you enough to make this easier for you. And a well-prepared plan is going to avoid conflict and allow your family to grieve together and to continue on life as a family. So what are a few key takeaways? Step one, create a foundational estate plan. It's that base on which you can build everything else. Remember that your legacy is not just your wealth. It's your values, it's your vision. It's the impact you want to make on the world and your community. Conflict often comes from silence. So it's okay to talk about this. It is uncomfortable. And most of us have been raised, you just don't talk about this. But it's very helpful in avoiding conflict to communicate what you want, who you want to take control, what you want to happen. And then if you have the wealth, you should consider advanced wealth transfer strategies to avoid taxes and to increase what you are giving to your loved ones. Remember that planning today is an act of love for tomorrow. So I'm going to open it up to questions. Let me know, what family dynamics are you most concerned about, or any other questions you have about estate planning.
So we don't have questions in the chat, but if you have a question, why don't you raise your hand and oh, here's one. If your parents set up a trust in Colorado, what happens if they move to be closer to one of their children? Do the trust rules change from state to state?
So first, I'll say it depends on what the trust says. Typically, a trust would say that this is under the laws of the state of wherever the trust was signed. So it would continue, the trust continues no matter where they live. The question is, what state rules control the trust? So if the trust says that the rules of Colorado control it, they will. There are ways that you may be able to change that. Some trusts say if we move, the law controlling laws move with us. That's kind of rare, though, for a trust to say that. More often, you might see a trust that says the trustee can change the controlling laws based on where the trustee is located. And then if it comes to it, you could potentially go to court to have the trust modified. So if you were in California, you could ask the court to modify it to apply the rules of California. But the trust remains, and so whatever provisions are in the trust don't change.
Okay, and Tina asked, can you comment on Prop 19 and any loopholes available on property tax setup?
So if there are people here who don't know what Prop 19 is, prior to 2021, a parent could pass down their personal residence of any value, it could be worth millions, and $1 million of basis for additional property. So let's say mom and dad bought a home in Hillsborough back in the 70s for $100,000, and now it's worth 12 million. And back then they also bought several buildings, and the property tax basis on those buildings is really low because in California it can only go up a little tiny bit each year. So prior to Prop 19, the kids could inherit all of those assets and maintain the low property basis, and this is a real advantage. Prop 19 passed, and now you can only pass $1 million worth of your personal residence value plus, and your children need to also live in it after you die. So it's a very reduced benefit. So what are some kind of loophole strategies? One would be entity planning. So, transferring into an LLC. There are a lot of different steps to do this. So it's not one deed and that's that. Create documents. You have to gift out small portions to different people, put in LLCs, because once you hit a certain point, there's going to be a change in ownership in the LLC too. So it can be done in certain situations, very tricky. Other types of planning loopholes would be joint tenancy planning, where you transfer a very small amount to someone else, usually a child, and then that small amount, like 1% interest, is reassessed. And then the two of you put it into joint tenancy, making you original joint tenants, so that when presumably the parent dies first, the child receives the property without a step up in basis. But that comes with some big risks, because once someone else is an owner, their creditors can get to the property. So there are a lot of questions that need to be asked of someone before they want to actually put someone else on title their property. Because I see this where they think this is a great idea. They just go record deeds, and then it's too late. What's done is done. And if the children have creditors or get divorced because an ex-spouse is a creditor, it can cause a lot of problems. But it is a way. So there are some loopholes, but it's very technical and really easy to make mistakes. If you accidentally record the deeds too soon, it could be a step transaction doctrine where they compress it all. They say, well, you recorded 3 different deeds, but actually this is just one from mom to daughter, and that's it. It's reassessed. So it's possible, but you definitely need assistance with that.
Okay, there's another question. Actually, there's several in the chat now. How does the trust work when property is left to a relative in another country?
Yes, the foreign trust question. So the trust, it still leaves the property to the relative, and it's based on the provisions in the trust. So if the trust just says, give it outright to the relative in the other country, that makes it easy. If the trust is ongoing, you may have a foreign trust situation. That's not the end of the world. It's certainly possible. It's just that there are additional tax consequences of that. So those are just things that you would go through with your estate planner. But absolutely, you can leave assets to a foreign national, or you can leave assets to a U.S. national living in a foreign country. You can do that in a trust, no problem.
Okay, and then another question is, what's the process to specifically exclude somebody from receiving any inheritance?
So the process is pretty simple. You just need to put in the documents. Well, truly, you don't need to put anything other than not name them in the documents. But typically people will specify, I am specifically disinheriting this person, so that that person can't go to court and say, oh, it was a mistake. They didn't realize they left me out. So by specifying in the document, yes, I did in fact intend to leave this person out, then they can't really make that argument. People often put no contest clause in documents, that if someone contests this document, then they get nothing. Those, it's interesting in California, the pendulum swings both ways. Some, for a while they were enforcing no contest clauses, then they weren't enforcing them at all, and now we're kind of somewhere in the middle. But it doesn't hurt to put it in there. If you have concerns that someone is going to contest, again, you're going to plan around it. You're going to put a much more thorough no contest clause in your document and specify. You might put why you're disinheriting this person. So again, it's why, and why is that? You might say, I want to keep that to myself. It's because if the person, once they're in litigation, after you're gone and you can't speak for yourself, this is the way you're speaking for yourself. This is evidence in that lawsuit that the testator or the settlor, the person who signed the document, is saying right here why they did it. That's pretty strong evidence. Whereas if you say nothing, then again, it's the court guessing. Well, did this person actually forget that they had this extra child, or did they intend to disinherit them? And I've been involved in cases like this. Actually, one of the first litigation cases I was involved in way back in the early 2000s was a situation where the husband had a child out of wedlock. And the trust, the husband and wife trust, said, we leave everything to our children. Well, what does our children mean? Does it mean only the child of those two people, or does it mean any child that either of us has? So if you have concerns about that, you can definitely say something in the trust, and you don't have to specifically say the person. You can say, we only leave this to children that are the offspring of both of us, so you can do it that way as well if you have concerns about that. And I've had more recently, I represented someone. He was in a famous band and had done a lot of road travel and whatnot. And there were concerns there could be extra children out there in the world. And so we definitely had some strong language that everything was only to be going to the named children in the instrument.
Okay, there's a few more questions, and let's see if we can get them through them.
Sure.
So how does an irrevocable trust work at a high level to protect assets from children's divorce?
So that's a great question. And it's really important because people often don't realize this. But if basically you put the terms in the trust as to what you want to happen. And so you can clarify what distributions can be made for. And oftentimes people put in health, education, support, and maintenance. But you can put in less, you can put in more, you can make it completely discretionary for the trustee. And then it's super important who you name as the trustee. But if the trustee has complete discretion, nobody can force out anything, including an ex-spouse. The one caveat in California is for child support. The court has determined that that's important enough that no matter what you put in the trust, if you owe child support, that will come out. But it's easy to draft to make sure an ex-spouse doesn't get anything.
Okay, Robert puts, it's difficult to figure out who's going to be the executor. Choosing a child may cause conflict. Do you recommend selecting an executor aside from your children?
So yes, it can cause conflict. First of all, just to clarify, typically in California, it's successor trustee. While we do name an executor in the will, usually that person never takes over because there's no probate. But I'll be honest with you, most clients do pick one or more children, and absolutely that can cause conflict. Again, though, if you talk to your children in advance and tell them why you're doing what you're doing, then maybe you can work around that. Some other options, if you have other family members, if you have siblings of your own or friends, if you don't have those options, there's what's called private professional fiduciaries. In California, they're licensed by the state, and they're cheaper than, say, a corporate trustee, which is another option. But a private professional fiduciary usually charges by the hour. It's around plus or minus $200 an hour at the moment. So that's an option. You can name multiple children. I would never suggest naming an even number, because then if they don't agree, you're in court to ask the court what to do. You could name 3 children or something. You could name a trust protector to help. It's, again, it's one of those conversations to have with your planner, the person that's assisting you, as well as with your family, if you're comfortable doing that. But you can name whoever you want. And so it's really what you think might be the best option.
Okay, another question. Could you distinguish between a revocable and an irrevocable trust? And another question, is a will always advisable beyond a will? Not sure what that
Okay, so what a revocable trust is, fully revocable and amendable by the person who sets it up. And that person is often called the grantor, the settlor, the trustor. All those words mean the same thing. It's the person that's putting assets into the trust and signing it. They can amend it, revoke it, do whatever they want. In California, if a trust is silent on whether it's revocable or irrevocable, it's revocable. In other states, it's the opposite. So be careful there. Irrevocable trust, once it's created, the terms are set in stone with a little asterisk there, because it is possible to go into court and have it modified. And there are quite a few ways to do that. I have done it a lot, but the basis is you as the grantor cannot just change it by yourself at any time the way you can with a revocable trust. And the reason why you go to court and the things to consider really is the IRS, because the reason most of the time you set up an irrevocable trust is for some kind of tax benefit. And so in that case, you want to make sure that the IRS doesn't come later and say, well, wait a second, you don't get the tax benefit anymore. There are some other reasons, like, for example, a special needs trust. It's a particular type of trust with someone who has special needs, or a drug or alcohol addiction, some kind of problem where you don't want them to have direct access to the money, and you set up this special kind of trust. So that's not necessarily tax driven, but it is irrevocable so that you make sure that the beneficiary who has the special needs wouldn't lose benefits or wouldn't be able to take the money and spend it where you don't want them spending it.
Okay, and last question, and then we'll have to say goodbye, is do you have a website? I just tried to Google it.
No, it is not. It is not set up yet. I do not. I have the domain name. I'm having a little bit of issue right now, and so you go there, and right now it's just contact us. But I will be getting that done at the beginning of the next year. I'm on LinkedIn and Facebook, and feel free to email me. You can also go to the State Bar website, has my there's an email address there as well.
Okay. And, but thank you so much. And thank you, everyone. We have, another speaker next week, but reach out to Kimberly. We're going to pass along, the recording to you all, and, it'll be on the YouTube library, and, we'll make sure that her contact information is sent out to you. So thank you, Kimberly, so much. Appreciate this. This is always really an interesting area, right?
Yeah.
So we have Luke back next week, and then the following week we have an AI job search tool that's going to be shared with you. So lots coming up, and we have a very full October as well. All these great speakers are coming at us, so fun stuff, looking forward to. So thank you, everyone. Don't hesitate to reach out if you need our support in any way. And thank you, Kimberly. Enjoy the weekend, stay safe, and we'll see you next week. Bye,
Thank you
everyone.
so much.
Thank
Bye-bye.
you.
Thanks, everyone.
Have a good day.